Are you staring at yet another legal bill from your family lawyer and thinking, when can this stop? Are you tired of getting triggered and feeling exploded every time you're getting an email from your ex or your ex-lawyer? Are you terrified of the upcoming court date? Can't believe you have to deal with all this crap on top of everything else that you're dealing with. The family court system feels like it's designed for draining your bank account as well as your energy and last bit of sanity. In this video, I want to give you 9 practical moves you can make right now to take control of your legal bill, protect your finances, and stop the drain. This is not legal advice or financial advice. This is my personal expensive lesson learned that I compressed into do's and don'ts, just so you don't have to go through the same thing. I've also created a quick quiz for you to go through it by yourself, find out what is burning your legal bill the most right now and what you can focus on first. Grab the link in the description. Number 1, detach your emotion from the process. Have you had this moment? You got an email from your ex-lawyer, the one that makes your blood boil, your stomach drop, you can't breathe, call your lawyer, or send a super long email to text vomit. I know I've done that. Your lawyer will spend like an hour with you on the phone. It's easy $500 down the kitchen sink. And not even that, it doesn't solve your problem. Your lawyer will probably say something that don't help you emotionally at that time. They may say it's a valid argument, and that's definitely not what you're looking for. What you were hoping to get was a validation for your feeling. If someone's saying, oh, that email is so unfair, how could they say that? But you won't get that from your lawyer. Most of the time, some lawyers do provide emotional support, and those are expensive emotional support that gets billed every 5 minutes, and that's what's spiking up your bills. So the first and effective way is to stop using your lawyer as your therapist. We must cut all emotional reactive communications with your lawyer altogether. I know it's easier said than done, so I'll give you something to do instead. First of all, why do we feel like this? Because when we're in the family court, you feel like your life is on the line. Your body is releasing the stress hormones, adrenaline and cortisol. It's telling you that you're in danger. It makes you want to fight. It's completely normal. It's biology is what makes humans survive through tens of thousands of years. We just need to find a less costly and effective way to deal with these stress hormones and use them for our advantage. Here's some steps you can take. Next time, when you see an email coming in from a sender that you know is going to trigger you, don't click on open yet. Stand up if you're sitting. Stay away from your laptop. If you're on your phone, put your phone away. Do 30 seconds of jumping jacks. I'm serious. High knees, wall push, whatever you're comfortable with, intensive enough to get your heartbeat up. These physical activities will reduce the adrenaline. Now, only when you feel your heartbeat is up, you can open the email, but read it as a third person. Imagine you're watching a show, and this email is from one character to another. You just know what happened because you've been watching the show. So when you read it, you don't have to think about how to reply. You're just reading it and be curious about why this email is written this way. Why was certain things brought up? You don't have to think about how to reply. Read it only once and notice if there's any deadlines or urgency in it. And if you're so emotional already, can't even process it, as a third person, throw it into ChatGPT and ask it to analyze what's the key point of this email and what are the action items. If you have been conversing with ChatGPT, it will probably know the history and give you some good analysis. Close the email right away and say this to yourself: nothing to deal with right now. Check in with yourself. Is your heartbeat still high? You're still feeling the burn in your chest? If you're still in that zone, do not write an email to your lawyer. Don't do anything. Just close it. The next thing we need to do is to get back to the normal emotional state. If you can, I suggest stay away from a desk for a bit, even just 10-15 minutes. Go out for a walk, do some workout, or talk to someone else. This keeps you from carrying that fight energy into the next part of your day or into another email that you didn't have to send. Most of the time, after you take a walk or a couple of hours, you do feel a lot better. The original thing you were intended to send, you will no longer want to send. And if your case is really messy, it will be good if you have a psychotherapist in your pocket for your trust and you always go to, and they can be the emotional reset button during these high-stake period instead of going out for a walk. Another small tip that's really helpful to manage the emotion is to time box your email checking. Set aside just 15 minutes every day. Put it on the calendar. I call it worry time, and only check your emails during that time. Outside of the time, you're not allowed to check the emails. You can do so by filtering out the emails and put it in a different label so that you don't even see these emails coming to your main inbox. If you're interested in how to set that up, let me know in the comment and I can send you some instructions. Move 2, master BIFF communication. Just remember, every angry text or email that you send to your ex or ex-lawyers can be used against you later in court. Every time when you think you got all the points covered, argued perfectly, you send back a reply. They don't even address everything. And the only thing that will be discussed are the ones that can be used against you. They will take the words out of the context, and then they will appear later in the court documents as an evidence. Long text or emails are the most dangerous thing you can do in communication while you're in the family court. It gives too much unnecessary details and causing drama that will end up in high legal bills. If you haven't heard, BIFF, BIFF stands for brief, informative, friendly, and firm. Brief, short sentences, as fewer sentences as possible. Informative, no emotions, just facts. Friendly, a simple hello or thank you in the email. Try to be nice and professional. I know it's really hard, but just imagine you're writing to a colleague that you barely know. And firm, state your point or your request firmly and clearly. Make it boring, really boring, factual, and impossible to fight with. Eliminate the drama. That's the best way to reduce the legal bills. Let's take an example. This is a non-BIFF email look like. I honestly can't believe you did this again. You were late for pickup, like always, and because of you, the kids missed their activities again. And you go on, and you bring up this other time that your ex is also late, and so on and so forth. And this is what a BIFF version of this email will look like. Pickup today on October 29th was scheduled at 5 p.m. at school. Actual pickup was 5:27 p.m. Because of the delay, child missed her 5:30 p.m. skating class. Please confirm you can arrive for 5 p.m. pickup this coming Friday, November 5th. Thank you. It's brief, 4 short sentences, informative, with only the facts, and friendly. The tone is neutral and respectful. It doesn't attack characters. It asks for a confirmation for a specific time and date. No threatening, no begging, no emotion at all. With the BIFF version, there is nothing they can do about it. Your lawyer will not get involved at all. A quick way to get this done is next time you write an email, throw it into ChatGPT and ask it to rewrite it in the BIFF style. It usually does a great job. Move 3, know your goals. Right now, you're pulled into a fight. You might not even want to be in this fight, but you're dragged into it, and you're arguing about who said what 5 years ago in some angry text out of context. Have you been fighting for years and not even sure what you want as an outcome, and you just feel it's so unfair and I have to show the world how unfair it is? The brutal truth is the family court system only cares about what's the best interest of the child, and it has some principles on what is considered as the best interest of the child. They don't care about the fairness between you and your ex. It's a game that you won't win if you don't know the rules, and you have been probably playing this game without a manual for years. From this moment on, if you're not already doing this, everything that you say or write has to be examined through the lens of the best interest of the child. Imagine 5 years from now on, you're out of the family court. What does the divorce happily ever after look like for you and your child? Is it 50-50 parenting time? Is it living in the current house you're living in? Write them down and then rank them, but only pick 3 things that's your non-negotiables. That is the most important for your children. And cross everything out because you cannot get everything. And then share this with your lawyer to see if your lawyer agree that these are all doable and reasonable, and then form a strategy around that. Once you're clear about your goals, that's only 3 things that you care about. All these other things that's brought up are just noise. Next time something was brought up and you want to discuss it with your lawyer, check if the discussion will serve your 3 goals. If the answer is no, you probably don't even need to discuss it. Just document it and ignore it. It may be useful later, but for now, this is not useful information and not something you want to spend your legal fees on. If you use this criteria, you'll be surprised how many urgent issues don't even need to be discussed. Move 4, be your own paralegal. I don't mean you have to get a law degree or certificate. What I mean here is to be organized and do the legwork for your lawyer. Imagine handing your accountant a shoebox of crumbled receipts and say, do my taxes. That's what we're doing when we're sending our lawyers 50 screenshots with no titles or a messy folder of evidence. You will be billed $200 an hour at least for a junior associate just to sort your documents. The more organized we are, the smaller your legal bills will be. So how to be your own paralegal? First, you need a system to organize your documents. You can use Google Drive or anything you can share with others and keep your versions. And then you need a logical folder structure. You can have one folder for evidence, another folder for finances, something for court documents. After you dump everything in the right folder, make sure you change the files, name it so it's not something like offer to settle V5 final. In 2 months, you'll forget what V5 final actually means. You can name it the same way your court court requires to check how your lawyer is labeling the files. For example, date, Form 25, applicant initials, that's organization. On top of that, you also need to make a few extra documents and keep them up to date. First is a timeline document. You can use a Google Sheet. It captures dates and important facts like moving together, separated. If you have financial issues like child support, house, you will need another document to capture date, activity, amount occurred, and why it's beneficial for the child. It will also suggest you have a case brief. It's a short, fact-based story that captures what happens in your case. Like, when were you together? When you separated? What's the reason you separated? Use the BIFF method to keep it simple and factual. This is a document you can use over and over to interview lawyers or someone new is involved in your case, like a social worker. Having the document ready is going to save you so much time, and more importantly, it's going to save you so much money. Keep owning the minimum useful information for that professional to do their job. They don't have to hear your life story. They just need to know what they need to know. And it also saves you the emotional disturbance every time you have to talk about your story. It's very easy to rant or get into that emotional state when you talk about it because it's emotional. And it's normal that you feel emotional. But to save legal fees, we have to cut that to the shortest you can. If you have a meeting with your lawyer for the first time, this should be covered within 5 minutes of the first meeting. It's the foundation of efficiency with your lawyer. Especially at the beginning, most lawyers charge 8 to 10 hours just to ramp on your case. If your lawyer costs $600 per hour, that's the easiest $3,000 just to ramp on your case. Sometimes that's also the biggest barrier for us to switch lawyers because it's too expensive to ramp up. Having an organized system with a clear case brief for your lawyer is going to cut this process to 2 to 3 hours. If you're not sure what aspects are burning your legal bills most, I created a quick assessment for you to go over that by yourself. You can grab it in the description. We've covered 4 moves which can cut you thousands and thousands of dollars already. Now let's move on to a little bit more complicated stuff if you are in the system for a long time. Move number 5, print the first draft yourself. I know it can sound complicated. It's not rocket science. Just have to do it once and then you will know how to do it. The first draft can easily cost 5 to 10 billable hours because your lawyer has to get on a call with you, ask you questions, distill the story into narratives and write it down, and then go back and forth with you to make sure it's all correct and reflect what you wanted to say. After you worked with one lawyer for a while, you probably feel that the lawyer should know everything, but they don't. They have dozens of clients and you're just one piece, and they don't know all the details of your history. Other than the time that they're with you on the phone and dealing with your document, they're not thinking about your case at all. They have certain templates and things that they know that will make a good story, so they follow their templates and ask you questions to fill in the boxes. Many times, you'll have back and forth edits to get the story right. And if you stay passive in this process, it will be very costly. And you are the one who knows all the details of your story. Let's do it ourselves. Your affidavit is your story. You know it best, but don't write an essay. Let's use the BIFF method as well. Just say the truth, state the fact. The more neutral and factual your draft is, the less edits it will require from your lawyer. And don't worry about big words or have to sound like a lawyer. That's your lawyer's job. You just need to tell your story. Next time you have a court date, try to download these files from your court website and fill them in yourself for the first round. This move alone will save you thousands of dollars, if not more. Next move. Be prepared for your meetings with your lawyers. Every time you have a meeting, you need to have an agenda and a goal. I used to be completely passive in this process, and I'm thinking I hired a lawyer and they know what to do. I just let them do their job and they should deal with it. And most of the time, I don't think about it until my lawyer reaches out to me because of a deadline is coming up. That usually means a super stressful couple of weeks and a few crazy legal bills. I want you to take the driver's seat and be the case manager yourself. The reason you're feeling stressful and then so anxious with these situations is because you don't know what's going to happen, what we can do, and what all the legal jargon is about. What is a motion? What is a case conference? How is it different from the real court? What to expect in the court? So let's solve that problem by understanding more about the court system so that you can feel in control and know where you're going. Your lawyer is only hired by you to give you legal advice. You stay the captain of your ship. Never go to a meeting with your lawyer without knowing what you want out of it. You must have an agenda so that in the meeting, you can just go over your agenda and get all your questions answered. I found it also helpful to have a timer on the side because you're billed every 5 minutes and just visually see time going through. It will keep you on track without going into the emotional rant. The next level up is to use unbundled help. One option to effectively manage the legal bill spikes is to use unbundled legal services instead of full retainer. They're sometimes also called limited scope scope retainers. This is more difficult because now you're not just the case manager, you're taking on the whole case by yourself. You're a self-represented litigant, and you're only outsourcing the part that needs legal input. If you're in a super heated situation or you don't have time or mental space at all, I don't recommend this. But if you can, this can be a lot more manageable financially. Some lawyers even offer flat fee packages to help you only draft the separation agreement or only do the financial part. This works better on the low conflict cases where both sides just wanted to settle. If you do choose this route, I will suggest you have a divorce coach who can help you with talking through the emotional daily things, strategies, how to respond to certain emails. These are the things that your unbundled lawyers won't help you, but the divorce coach can give you some guidance and help you emotionally as well. Move 8, choose the easier route if you can. Court is the most expensive, slowest, and most emotional damaging way to resolve a dispute, in my opinion. Avoid it at all costs if you can. There is no winner in the court, even if someone in the end get more than the other side. It's a smooth situation because everyone spends so much money, energy, and life in the court system that they could have spent someone else. If it is safe for you, which is a big if, and if your ex agrees to it, which is another big if, mediation or arbitration can be effective. Even if you can't settle on everything, you can reduce the number of issues. And if there is a way for you to choose the easier route, do it early. The longer you stay in the court, the more expensive it becomes. The last move is to tackle the issues one by one. Right now, your case probably feel like one giant, impossible monster. The kids, the house, the money, the debt, everything all at once. And often the other side will try to fight you on everything all at once. That's when they file a 10-page motion asking for everything they know you won't agree on. Here's your move. You refuse to fight for the whole monster. Think of your case as a giant tangled knots of fishing line. There's the parenting line, the house line, the finance line, the kids line. They all hopelessly twisted together. The expensive, panicked way is to grab the whole knot and pull. That's not going to make it better in any ways. I know this is sometimes the most rational thing to do because you want to show the whole picture so the court will know, but the court won't know and they won't see the things the way you do. The fight about everything is just making the knot impossibly tighter and more expensive to untangle. But let's find one single line to untangle first, the most urgent one, or the one with the least conflict. Let's solve that one piece and then move on to the next. You see where I'm going? We solve it piece by piece. You can turn a giant monster into a series of smaller, manageable discussions. It's faster, focused, and as the monster shrinks, so as your legal bill. There we go. 9 moves that you can take right now to take back of your financial control and be the boss of your case. This is not just about saving money. It's about protecting your limited resources, your energy, your future. So you can focus on what actually matters, building a good life for you and your child. Especially if you got a neurodivergent kid, there's so much more that requires your energy. If you are feeling heavy and not knowing where to start, cut your legal bills first, I've created a quick assessment for you in the description so you can find out where is bleeding the most and where to focus on first. Thank you so much for watching the video. I hope this is helpful. I'll see you in the next one.